Noah Feldman. He's a man that Paige Williams tapped for advice on self-defense for her article, Kyle Rittenhouse, American Vigilante. He's a brilliant legal scholar, and I don't mean that sarcastically. Actually, he is really quite sharp. But unfortunately, about the last person that she should have contacted on this issue. We're going to examine his background and why Paige Williams would have asked for his advice in the first place. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
We have been examining this article by Paige Williams in terms of its bias and objectivity. Now, the liberals are out there going, oh, wow, this is such an objective, unbiased approach toward examining what happened that night in Kenosha. And I have a whole bunch of videos that prove otherwise. This is going to be another one, because Paige Williams devotes a portion of her article on self-defense rights. Now, she has to explain that to her readers, and guess who those people are? Well, what do you think the typical New Yorker reader is? The person who hangs out in Starbucks and has a couple of novels, French literature and stuff, and thinks that they're part of the intellectual elite. And so she's going to tap somebody that they can relate to, a Harvard law professor of high esteem, but one also guaranteed to present an argument that's going to appeal to the readership. Make no mistake about it. Kyle Rittenhouse, American Vigilante, is a real slam on Kyle. It is not unbiased. It is quite the liberal attack. So let's go ahead and let's read it. Well, at least the paragraph where Noah Feldman shows up. If you want to have my opinion on the entire article, again, I'll link in the description below a whole bunch of links that you can go to and watch. So it begins. Many people in Wisconsin expect the jury to determine that the DA overreached when he imposed the charge of intentional homicide. Yeah, he did, but okay. Yet Rittenhouse could still go to prison if jurors hold him accountable for the deaths. In other words, if the jury decides to come back and convict him, he could go to prison. Wow, that's amazing insight we're getting from Paige Williams there. The Harvard law professor, Noah Feldman, it's the Harvard law professor, Noah Feldman, recently wrote that though Rittenhouse presumably will claim that he feared having his gun wrested away and used against him, it's only the presence of Rittenhouse's own weapon that gives him the opportunity to claim that he was in fear of bodily harm. And as I've mentioned many times, so what? If I attack you for the purpose of taking your car key so that I can jump in your car and run you over, what does that mean? Let's take a look at this article. Noah Feldman. Think the Kenosha shooting case is simple? It isn't, because of the gun Kyle Rittenhouse brought with him. And this was published in September 11th, 2020, about 3 weeks after the shooting. 2 weeks. You'd think it would be easy to determine whether Kyle Rittenhouse can successfully plead self-defense after killing 2 people and injuring a third during protests in Kenosha, Wisconsin. Now, keep in mind, when he says you'd think it'd be easy to determine, most of us that have been watching these videos I've been pushing out would say, yeah, it would be pretty easy to show that Kyle acted in self-defense, but no, that's not how Feldman's looking at it. He's saying you'd think it'd be easy to convict him, okay? And it's going to be plainly clear here in a moment that's exactly what he thinks. Turns out that it's actually pretty complex. Here's why. When gun rights get involved, the law tends to depart radically from common sense. Okay, so he's laying it out here. He's basically saying that gun rights screw up the whole notion of self-defense. It would be easy if it wasn't for those pesky gun rights that people have in this country. The legal framework on its own is relatively straightforward. In Wisconsin, as in many other states, you can use deadly force in self-defense if you reasonably believe it's necessary to prevent imminent death or great bodily harm to yourself or others. Okay, so he has that right. You can't avail yourself of the self-defense argument if you've provoked other people into attacking you. Well, no, that's not necessarily true. If you flee from the scene and give adequate notice to your attacker, you can reassert your self-defense rights. I have a lot of videos on this. And I would also say that you have to be careful. The provocation in Wisconsin has to be unlawful conduct. It specifically states so. So the whole idea that if you just provoke somebody into attacking you, that you lose your self-defense rights is not necessarily true. And again, I mean, he doesn't understand Wisconsin self-defense laws. I think he kind of opened them and read them. He didn't read them with real comprehension, though. Some states have a rule that says before you use lethal force in your own defense, you have a duty to retreat. In other words, you have to try to run away before killing your assailant. Wisconsin does not impose this duty. The jury is, however, allowed to consider whether it was possible for you to run away as part of its determination of whether you acted reasonably. And here, he's basically leading his audience around by the nose. What's he doing here? This is a tactic. We all know that Kyle Rittenhouse fled the scene in all three attacks. He was running away from his attacker. So why is he bringing this thing up in the first place? What's his duty to retreat? Well, again, he's trying to make a claim that Kyle Rittenhouse is still guilty somehow, and that the jury could still somehow convict him. So he's going to plant in the reader's mind this idea about duty to retreat, and the reader is going to come away with the feeling that, well, maybe Kyle didn't. Let's read it again. The jury is, however, allowed to consider whether it was possible for you to run away as part of its determination of whether you acted reasonably. And so he's setting this thing up as if the jury is going to have a rough time with this. The jury is going to have to deliberate for a long time to understand, well, now, did Kyle Rittenhouse run away? Well, yeah. I mean, if you watch the video, he's clearly doing it. Now, that doesn't necessarily exonerate him. I mean, there's a lot of complexity to Wisconsin self-defense laws. But on this part, it's really clear. He is fleeing his attackers in every instance. There's no doubt about it. But Noah doesn't want to really admit that. The trouble begins. Okay, now, what does he mean by trouble? He means the possibility of exoneration. That's his trouble. The trouble begins when you start applying the legal rules to someone in Rittenhouse's situation, namely someone who has carried an AR-15 style weapon to what is intended to be a peaceful protest. Oh, it was intended to be a peaceful protest. Who cares if it was intended to be a peaceful protest? It wasn't. It was a riot. And notice he mentions he's carrying an AR-15 style weapon. If you know Wisconsin self-defense laws, you know that makes no difference whatsoever. It is a long rifle. The AR-15 is treated as a long rifle, just like any other long rifle in Wisconsin law. So why even bring up the AR-15 style weapon in the first place? Again, think about Paige Williams' readers. The AR-15 is a dog whistle. I mean, it just plants guilt on anyone carrying one. And notice how he is really upset in a way that the law will allow Kyle Rittenhouse to defend himself in this situation. I mean, Kyle, we could punish him. We could convict him if it wasn't for that pesky law that gets in the way. Well, I thought we were a nation of laws. Yet under Wisconsin law, adults are entitled to carry around their licensed firearms in public places. An open carry law means that prosecutors would have a tough time convincing a jury that simply carrying an assault rifle counts as a provocation. It's especially troublesome when the Wisconsin Department of Justice, in an advisory memorandum dated in 2009, basically states the following. Now, this is coming from who? The Attorney General of the state of Wisconsin. And if we look at this, the Wisconsin Department of Justice believes that the mere open carrying of a firearm by a person, absent additional facts and circumstances, should not result in a disorderly conduct charge from a prosecutor. So if you can't even get a disorderly conduct charge from a prosecutor based on this, how are you going to negate a self-defense claim? Remember, provocation requires the act to be unlawful. And even Noah Feldman, leftist professor from Harvard, agrees. So all of you out there who are thinking that, well, Kyle was carrying that rifle around, that's provocation, isn't it? No, not even Noah Feldman agrees with that. And believe me, he really, really badly wants to believe it is true, but it's not true. Rittenhouse was only 17, and the law bars minors from gun possession. Yeah, that hasn't been decided yet. But there is no reliable way that bystanders could have known that Rittenhouse was underage just by looking at him. And it wouldn't have mattered even if they could, because whatever unlawful act that you're going to use to, say, provoke your attacker, I don't believe that just simply being minor in possession would be enough to do that. I mean, you see a kid walking down, he's only 17. Let's suppose you know he's only 17. And let's say that the law doesn't allow a 17-year-old to carry an open rifle. Does that mean you're going to attack him? I mean, I sure as hell wouldn't. Provocation is in the eye of the beholder, and the beholders would have had no way of knowing that Rittenhouse was engaged in an illegal act because of his age rather than a protected act, which it would have been had he been a year older. Okay, he's right for the wrong reason, but we'll go ahead and let it go. Common sense is even further displaced. So everything we've been hearing is him complaining that Wisconsin law is irrational, unreasonable. And he continues, common sense is even further displaced when you start to think about how Rittenhouse would claim to have reasonably considered himself to be in danger of imminent death or bodily harm. Oh, this is going to get good. The criminal complaint against Rittenhouse says that Joseph Rosenbaum, his first victim, approached Rittenhouse and then followed him. Are you kidding me? Did he not watch the video? He approached Rittenhouse and then simply followed him? I think it was an ambush. I think that Joseph Rosenbaum chased him. Cell phone video shows Rosenbaum, who doesn't look like he's got a gun, throwing a plastic bag at Rittenhouse and missing. Rittenhouse then allegedly shot Rosenbaum 4 or 5 times, killing him. See how he has phrased this. Again, keep in mind, who's he writing for? It's the audience for the New Yorker. Okay? It doesn't look like Rosenbaum has a gun. Who cares? You're not required to have a gun to pose yourself as a serious threat. But in a way, he's saying that you do. That's the implication. When he sets it off with these M dashes, who doesn't look like he's got a gun, that's an actual emphasis there. And why would you emphasize that unless you're trying to plant the seed in your reader that that's important? But it's not. Throwing a plastic bag at Rittenhouse and missing doesn't mention that the plastic bag was not empty. Now, it might not have had anything really heavy in there, but to say simply that he was throwing a plastic bag, that's misleading. And of course, no mention of Joshua Zeminski's gunshot, or the fact that Joseph Rosenbaum tried to take Kyle's gun from him. Ordinarily, being merely followed, as if you're walking along and the person is paced behind you, being followed or having a plastic bag thrown at you would not be enough evidence to show that you were in reasonable fear of your life. If someone threw a plastic bag at you and you responded by killing that person with your bare hands, you would most likely go to jail for murder. He's trying to frame this as Joseph Rosenbaum was walking behind Kyle and just took this empty plastic bag and threw it at him, and then Kyle turned around and shot him. That's what he's saying here. Again, keep in mind, the audience for the New Yorker is not well versed in what took place in Kenosha that night. I don't even think Paige Williams is. They haven't seen the video footage. They don't know what happened. A lot of them are going to get their impressions of what happened that night from Paige Williams's article. And if they click on the link and read this is only going to reinforce the notion that Kyle was simply just walking around being a pest, and Joseph Rosenbaum walked behind him and Kyle opened fire on him. A gun twists that logic. Rittenhouse can and presumably will claim that he feared Rosenbaum would take his gun away from him and shoot him with it. In other words, the presence of Rittenhouse's own weapon gives Rittenhouse the opportunity to claim that he was in fear of bodily harm. So far, what is the impression we're getting? Joseph Rosenbaum is walking behind Kyle, throws a plastic bag at him, misses. Kyle, with no good reason, believes that, I think that Rosenbaum might try to take my weapon from me. I better just go ahead and nip this in the bud, turn around, and shoot Joseph Rosenbaum. That's what the reader is getting from this. It seems a little short of absurd that a person who carries a gun in public and is then pursued could use the fact that he and not his victim was armed to claim that he had to shoot in self-defense. Why is that so absurd? You need to explain that. It's not self-evident. I certainly don't believe that's absurd. If I'm carrying a gun in public and somebody chases after me and tries to kill me, or at least I believe they're trying to kill me, I can use the gun and shoot in self-defense. Hell, that's why I'm carrying it. So what's so absurd about it? Well, it's absurd to people like Noah Feldman, and in a little bit we'll understand why. And maybe a jury wouldn't buy it, but it is not unlikely that a judge would allow him to advance the argument. Well, of course he's going to allow him to advance the argument. If he didn't, this would be a strong appeal. Again, the existence of laws that allow open carry is distorting ordinary logic. In other words, the logic of the left, the anti-gunners, the hoplophobes. They don't like it, and therefore it's, according to him, illogical. The second victim, Anthony Huber, allegedly tried to grab Rittenhouse's gun. So did Joseph Rosenbaum, according to eyewitness testimony. Notice, he doesn't mention that. He too was unarmed. No, actually, he was armed. Some accounts suggest that he may have hit Rittenhouse with a skateboard. He wasn't unarmed. Actually, it's pretty well a given now. We know that he hit Rittenhouse with a skateboard. Rittenhouse has the bruises to show it. Of course, by now, Rittenhouse had shot and killed Rosenbaum. That could possibly be depicted as an act of provocation, so that Rittenhouse cannot claim self-defense in the shooting of Huber. Huber never saw Kyle shoot anybody. How could it be provocation? He didn't see it. We know he didn't see it. His girlfriend sort of spilled the beans on that one already. In a sensible world, he keeps doing this. Everything to him is sensible, logical, reasonable. If it agrees with his preconceived notions of what self-defense laws should be like, who's to say he's the guardian of rational self-defense laws? In a sensible world, the fact that Huber may have tried to disarm Rittenhouse, who had just shot Rosenbaum, would turn Huber into a martyred hero, not someone who posed a lethal threat to the shooter. So let me explain something to Noah Feldman, because obviously this has gotten by him. It doesn't matter if Anthony Huber had the best of intentions. It doesn't matter. All that matters in self-defense in Wisconsin and pretty much every state is, what did Kyle think? What did he believe? And I've mentioned this on numerous occasions. It's quite possible for two people to get into a confrontation and both of them have a legitimate right to self-defense. Just because Kyle has a right to self-defense doesn't negate Anthony Huber's right to self-defense, and vice versa. And so whether Huber had the best of intentions is not relevant. The logic that turns an unarmed skateboarder, into someone whom Rittenhouse could shoot the logic that turns an unarmed skateboarder into someone whom Rittenhouse could shoot in self-defense again hinges on the presence of the shooter's own gun. A jury could be convinced that Rittenhouse was acting in self-defense when he shot Huber, again because he was afraid that Huber might take his gun and shoot him, or hit him with a skateboard. Finally, Rittenhouse shot and injured Gage Grosskreutz, who approached Rittenhouse while armed with a handgun. This is the only one of the three shootings that should even be conceivably considered a potential self-defense, because Grosskreutz was armed. Again, he uses the word should. In other words, in Noah Feldman's little world, that's the way the law should be. But it's not. But if Grosskreutz believed that Rittenhouse was a shooter on a spree because Rittenhouse had just killed two men, then it also defies common sense, again, defies common sense, to think that Rittenhouse was entitled to shoot him in self-defense just because Grosskreutz was armed. What about Grosskreuz's right to self-defense? What about it? Again, he's a brilliant legal scholar, but he doesn't have any self-defense background. And so the whole idea of both people having a right to self-defense gets by him. He doesn't get that. But I can give you a very easy explanation as to why that must be the law. And again, I've used this before, but you hear an alarm go off and you see somebody escaping from a bank. And so you chase after him. The person who's running thinks you're out to kill him. So he turns around and pulls a gun. You pull a gun. Both people have the right to self-defense. The upshot is that Rittenhouse's self-defense arguments may well go to a jury. Yeah, I think that's pretty much a given. And it's not at all impossible that a jury might acquit him, except on the illegal underage possession of firearms charge. They may not be able to actually examine that one because the judge might actually dismiss charges on that. I think it's about 50-50. If that happens, the law on the books will have more or less been followed. Oh, damn it. Oh, no. They followed the law. But the gravitational pull of the right to bear arms will have made a mockery of our aspiration for the laws to make common sense. When there are guns involved, common sense goes out the window. Yeah, okay. Let's take a look at Noah Feldman's background because it's actually quite interesting. And right here, you kind of see the issue. Born in Boston, he went to Harvard, and then he went to Oxford in England, and Yale. And essentially, all of these locations are going to be very urban, very leftist, anti-gun, especially Oxford. Okay? If you read his background here, he earned a Rhodes Scholarship to Christ Church, Oxford. Okay, very lofty, no doubt about that. And he earned a Doctor of Philosophy in Islamic Thought in 1994. He's a hyper-polyglot, which is pretty impressive. He can do a lot of languages there. So in 2001, he became a tenured full professor at the New York University Law School. He was named senior constitutional advisor to the Coalition Provisional Authority in Iraq. So he helped draft Iraq's constitution. Probably didn't do much on the Second Amendment portion of their constitution, but whatever. In 2007, he joined Harvard Law School and taught classes in what? First Amendment, the Constitution, and the International Order. Senior adjunct fellow at the Council on Foreign Relations. When you read the titles of his books, it's all about foreign relationships. His real background is centered on Judaism, Islam, and the First Amendment. He has no background in the Second Amendment, self-defense, or anything. He has lived his entire life, for the most part, in these little liberal enclaves. They're highly urban. They're very anti-gun. He has no Second Amendment experience. He has no self-defense experience. He's never been in the military, as far as I could tell. I'm not sure he's ever fired a weapon. I don't think he's ever even held a gun. I checked out his wife. It turns out that she has almost the same background, pretty much has lived in the same areas. Cambridge, Oxford, so on. I mean, take a look at his books. After Jihad, America and the Struggle for Islamic Democracy, What We Owe Iraq, War and the Ethics of Nation Building, Divided by God, America's Church-State Problem, The Fall and Rise of the Islamic State, The Battles and Triumphs of FDR's Great Supreme Court Justices, Global Competition, The Three Lives of James Madison. Well, that might be something, since he wrote the Second Amendment. The Arab Winter, It doesn't even appear that he's ever actually argued in front of a judge, as far as I can tell. In other words, he's never served on a defense team or even for a prosecutor. So why Noah Feldman? He's got a big name. He's brilliant. I mean, there's no doubt about it. But his expertise is in Islam, Judaism, foreign relations, the First Amendment. He has no background in self-defense. He has no background in the Second Amendment. He'd be the first to line up to get rid of the Second Amendment if he had the opportunity. Because he doesn't come from a gun culture. He doesn't understand rural life. Every city he's lived in, Boston, Cambridge, New Haven, are all liberal enclaves. They have very few weapons. Most of the people there may have not even ever held a weapon in their hands. And so, to Noah Feldman, the idea of a person owning a gun is anathema alone. Carrying one in public, well, that's insane. And so any law that allow anyone to use a gun in self-defense to him is illogical, irrational. And of course, the propaganda tactics are in there. He completely whitewashes all of the events to paint Kyle in the most negative light possible without actually lying. He just leaves things out because he doesn't want the reader to think that he may be on Kyle's side, or at least understands how Kyle could legitimately claim self-defense. So he has to paint this self-defense argument as irrational. Not my fault. I'm just the messenger. We all know that in a logical world, he'd be guilty. We'd throw him in jail for 60 plus years because he used one of those guns to defend himself. And so Noah Feldman is the bearer of bad news. He's also a perfect example as to why, if you're going to talk on a subject, study it first. Just because you have a Juris Doctorate doesn't make you an expert in law. It makes you an expert in those areas of law that you have studied. I've said this many, many times, that if you get a civil lawyer and you ask them their opinions on a criminal case, their opinions are worthless unless they've actually opened the books and they've read the statutes and they've studied them. I mean, you wouldn't get a foot doctor and have them do open heart surgery. But asking a civil lawyer about a criminal case is almost the same thing. Noah Feldman is even worse than that. He's not only not a civil lawyer, but he doesn't even practice law, to be honest with you. So be wary. Like my video, subscribe to my channel.